Hello and welcome to the PG&E Bankruptcy Forum, Distinguishing Facts from Fiction. This panel discussion is sponsored by a small group of fire survivor volunteers from across Northern California. My name is Jason Meek. I lost my home in the Tubbs fire, and I'll be giving a short introduction for us today. Wanted to let you know that this has really come together very quickly. In the last 5 days, we've mobilized and organized to try to help you get answers to the most pressing questions about the PG&E bankruptcy reorganization plan, the victim settlement fund, and the voting process. A lot of things have come together just in the last few weeks. There's still a lot of volatility in the stock market we've been seeing. We've been seeing also resignations of certain members of the official tort claimant committee, the TCC, who have been representing victims in the bankruptcy process. They resigned to protest the plan. There's still several ongoing negotiations about critical features of the plan and registration rights and other issues that affect the sale of the stock that's placed in the trust on behalf of victims. There's also been a distribution of voting materials by many of the lawyers representing victims, and we're seeing a range of recommendations from yes to no to hold on and wait. Fire victims seem to be struggling to try to understand the magnitude of the risk, what's been changing, and what's left to be resolved. And so we've tried to gather this group of panelists who've been experts in their fields as predominantly legal counsel, and they've been actively involved in the bankruptcy proceedings for many months. To summarize, this is not intended to be a debate necessarily. It's more a town hall for us to be able to explore issues and inform people who have an interest in all of the consequences of this deal. Since launching our website, firesurvivorsvote.com, we've received dozens of questions. We've communicated all those questions to our moderators today, Lily Jamali of KQED and Professor Jared Elias of UC Hastings College of the Law. They have used their professional judgment to choose from among the submitted questions, integrated those with other questions that they have heard from other survivors in the course of their interviews over time, and they've developed the themes and the questions that they'll ask the panelists today. So with that, I'd like to go ahead and welcome Lily and Jared to take over from here as moderators.
Lily, you're muted.
You're on mute, Lily.
Of course I am. Of course, that's how I would start things off here. Thank you so much for the introduction, Jason. I want to thank the organizers of this. I have been following this story for many months, and I appreciate the chance to try to just get some information out to people and understand what questions remain. In my own reporting, I have gotten to talk to a lot of survivors of these fires, as have my colleagues at KQED, and it's very clear that there are so many questions that remain. So it's a privilege to be a part of this. Thank you.
Right,
sorry, go ahead.
I just wanted to echo everything Lily just said. I'm a professor of law at UC Hastings, and I became aware of this story because the bankruptcy court is literally a couple of blocks from Hastings. And you know, I didn't know very much about the fire. I knew about the fires obviously because I live here in Northern California, but I didn't know very much about the energy industry. But I know a lot about Chapter 11, and so Lily and I are here today to serve as moderators. Neither of us have an interest in, or in this, other than we both live here in Northern California, and we care very much about a future more safely operating PG&E, and also many of you are our friends and neighbors, and we want you to, get back on your feet as quickly as you can. Apart from that, this is purely an informative exercise, and we're excited to get started.
So I want to encourage everybody to use the chat function on the live stream. I am looking at those, Jared is as well. And so that's a great place to leave questions. I'm actually going to probably ask as a first question, something that somebody submitted in that little chat area of the live stream. But Jared had prepared a little presentation, just kind of bringing us up to speed as to where we are right now. Things change every day. There was a bankruptcy hearing just this morning, some resolution on some pretty controversial issues. So this thing changes constantly. And so Jared, I'm gonna toss it back to you to just kind of tell us where we're at.
All right, so very quickly, I know that people are anxious to get started. PG&E filed for Chapter 11 last January, and Chapter 11 is the reorganization statute of the Federal Bankruptcy Code. PG&E filed for bankruptcy not because there was something, fundamentally flawed with their business, but also because they had all of these fires that they were liable for, or that they were alleged to be liable for. We've now spent the past year witnessing negotiations over a plan of reorganization. And there currently is a plan on the table that is supported by the official committee of tort creditors, which is the court-appointed representative of the fire survivors. As well, at the moment, at one point it was supported. It's not clear at the moment where things are at the moment, but they supported it at one point. And it's also supported by all of PG&E's major creditors, including the insurance companies, the hedge funds that are the company's shareholders and the company's bondholders. And we've now gone through a claims process, which many of you have filed claims for. And now we're in the voting period that will allow all of you to vote yes or no on the plan of organization. Once your vote is cast, Judge Montali will then hold a hearing at the end of May to determine whether or not he's going to confirm the plan. And while he could confirm the plan, even if the group of fire survivors vote no, he signaled that he'd be extremely hesitant to do so. That takes us to the discussion that we're going to have today. And Lily, I would turn it back over to you to identify our panel. Unmute.
I am so sorry, you guys. I'm still new at this whole webinar thing. I'm now going to introduce everybody, but I just wanted to point out, it looks like we have at least 500 people watching this, which is really cool. Okay, so I'm going to go around the Hollywood Squares situation that we have going here. I'll introduce everybody briefly, and then we'll go around and have each of you state your position on the $13.5 billion settlement and anything that you wanted to add to what I've said. So quickly, Bonnie Kane is an attorney based in San Diego. She represented a member of the PG&E Bankruptcy Official Tort Committee, Tort Claimant Committee, or the TCC as it's often referred to. And that member recently resigned. Bonnie, it's great to have you here. Francis Scarpula specializes in prosecuting complex civil cases, primarily antitrust lawsuits, most of which are class actions. He represented a member of the PG&E Bankruptcy Official TCC as well, another member who recently resigned. So Michael Watts, who, I'm sorry, my computer here is dipping in and out, so I'm losing some of my descriptions, but hopefully it sticks around for me. Mr. Watts is a lawyer whose group collectively represents the largest group of PG&E victim claimants, about 18,000 fire survivors. His practice area includes catastrophic personal injury, product liability, and commercial litigation. He is an official fire claimant professional. That's different from the TCC category in this bankruptcy proceeding. Gerald Singleton is also an attorney specializing in fire litigation. He represents over 7,000 victims from all the major fires in the PG&E bankruptcy. And like Mr. Watts, he is an official fire claimant professional in the proceeding. William Abrams is a survivor of the 2017 Tubbs fire. He's been an active party in the PG&E bankruptcy and the CPUC, or the Public Utilities Commission proceedings. And he was also, we should mention, a fire survivor who helped organize this gathering. And I think I covered everybody there. So first of all, thanks to all of you. Why don't we start with Bonnie? Just tell us your position on the settlement and anything that you wanted to add to what I said in my introduction.
Sure. Thank you, Lily. And I want to thank you for putting this together also, Lily. And thank you, Will Abrams, a fire survivor, for putting this together, and Jason and Jared for acting as moderators. It's like the bankruptcy judge said this morning, the hearing on the Butte settlement, a plea bargain, I should say, said, with regard to Mr. Abrams, he said, I definitely absolutely encourage you to express your point of view. And I think that that's the essence of this panel today. I also want to thank our client, Karen Goins, who has always put the fire survivors' interest as a paramount goal now, and also as a former member of the official committee of tort claimants, from which she recently resigned. And Karen is the former chief financial officer and controller of the town of Paradise. She's an accountant. So she has really followed this for well over a year and had a lot of input, but she got to the point where she could not justify supporting the plan, and that is why she resigned from the committee. My background, just briefly, is I've practiced for 26 years as a plaintiff's attorney, primarily in San Diego. We handled several hundred claimants in the 2007 wildfires here, the Witch Creek Fire, the Guajito Fire, and the Rice Canyon Fire. And so those fires also were against a utility. So we have a long background in legal knowledge on how to pursue the utility companies. But anyway, today I want to make sure we instill as much candor and as much transparency and provide information, because that's so important to the voting process.
Bonnie, thank you for that. And just to clarify, I'm a moderator. I, in the interest of full disclosure, did not organize this, but I am privileged to be a part of it. Let's go to Michael Watts. Mr. Watts, can you just tell us your position and we'll go from there?
Sure. I'm Michael Watts. I represent a large number of the fire victims, both in North Bay and in Chico. I spent months negotiating together with other fine lawyers, some of whom are on this this panel, against PG&E, against the equity folks, against the bondholders, and ultimately in December we negotiated a $13.5 billion proposed settlement that's now being voted on. I'm recommending to my clients that they accept the proposal, in large part because they've waited long enough to get their money. That money is here, and it's time to rebuild your homes. Secondly, I think this is going to be the third largest mass tort settlement in the history of the United States civil justice system. It's a lot of money, but it's only feasible if we vote to take it before the June 30th deadline for AB 1054, which is just pivotal for this to happen. I'm for the plan because I think it's a good plan that fairly compensates the fire victims, but more important than that, it's the only plan. If fire victims vote it down, we'll be waiting for years, in my view, and I don't think that that's what most of them want to do.
Okay, thank you, Mr. Watts. I'm getting a lot of notes in the chat to let's get to the questions. So let's keep these brief. I do appreciate hearing your backgrounds, but we'll get, you'll have a chance to talk more about your experience in the question. So 3 more to go. Mr. Singleton, why don't you go next?
Well, let's get to the questions. My name's Jerry Singleton. I represent about 7,000 clients. I support the plan for the same reason that Michael said. It's the only plan currently available, and realistically, it's the only chance to get fire victims a fair settlement in a reasonable period of time. If we don't approve the plan, then we're looking at 2, 3, 4 years before PG&E is sold off in bankruptcy, and in all likelihood, the amount victims will get after that wait will be less.
All right. Fran Scarpula, would you like to go next?
Sure. I represent, among other clients, GER Hospitality, which is owned by Adolfo Veronese. It was a restaurant in Glen Ellen, which is now defunct because of the fires. We opposed the PG&E settlement because we didn't believe that it was really $13.5 billion in consideration, because of the stock. And now that there's been a horrible economic crash, we don't even think the 13.5 billion is going to be doable. And there is an alternative plan from a group of customer-owned utilities that would provide 13.5 billion in cash on or before September 30th, 2020. And that's the plan, either as a backup to PG&E or as a new plan that we believe should be adopted.
All right, and William Abrams.
Thanks very much. So I am not an attorney. As was mentioned earlier, I lost my home and my family and I ran from the flames in October 2017. And since that time, I've tried to take my skills and experience to advocate. So I've been trying to engage in the CPUC in Sacramento around utility issues, but generally wildfire recovery issues. And reluctantly have been engaging a lot in the bankruptcy proceeding as of late, and trying to do my best to be representative of wildfire survivors and to really advocate for a better plan. I think that that's where I'm at, is that there's still time, and I'm hoping and supporting a better plan, and that's where I'm at on this plan.
Okay, thanks to everybody. We're going to get to your questions now, and we, Jared and I talked a little bit about how we wanted to structure this. We're going to start with the substance of the plan for folks who aren't as familiar, to kind of understand what's in it, what's not, what's left to be discussed and negotiated. Then we'll talk about the negotiating process. There are also questions about the voting process itself. Voting started April 1st. It's going to be continuing through May 15th. And there was at some point an effort by the Tort Claimants Committee to stall the vote, to allow time for some of the outstanding issues to be negotiated. So hopefully people who are on that side of the issue can discuss that. And then we'll just kind of have a grab bag of questions towards the end if there's time. And we'll be doing this until 7 o'clock Pacific. So my first question regarding the substance of the plan actually comes from the chat. Jeanette W. asked, are entities, and raise your hand folks if you want to take this one, so we'll try to get multiple perspectives here. Are entities other than survivors, so that would include insurance claimants and that would include local governments among others, are they receiving money first, and if so, why? Who would like to take that question on? Okay, Fran, go ahead.
I can answer that. Yes, the subros are getting $11 billion in cash, and I believe they get it on, well, less the $4 million that they're paying one of the fines, but they're going to get their cash right away, $11 billion. And I believe the public entity for the $1 billion settlement is going to get that in cash. The fire victims, on the other hand, are supposedly getting 5.4 billion on the date of the effective date, with a 1.35 billion paid over 2 years without interest and with questionable security. And then they're getting 6.75 billion in PG&E stock, which really, I don't know how they're going to do that, because if they gave them the value of 6.75 billion, I think that would be almost 25% of the company, or 600 or 700 million shares. Now, I don't know what I don't think that comes anywhere near 6.75 billion in cash.
Ms. Gerald Singleton, what say you?
That's correct, but the explanation for that I think is important. The subrogation insurers, and those are the folks that paid out homeowner claims, auto claims, and have a right to sue PG&E to recover those, actually had losses of 19.5 billion. And so they accepted a discount of more than 40%. It works out to about 58 cents on the dollar. And in exchange, they negotiated to get paid all in cash. The same is true of the local public entities. And we're not talking about the federal or the state. This is completely separate, but the local public entities, the County of Butte, the City of Santa Rosa, they receive $1 billion on claims that were valued at over $3 billion. So they took massive discounts, and that's why they received all cash. Now, we weren't willing to do that. We wanted the fire victims to either get paid 100 cents on the dollar or as close to it as possible. And so what we did was we took half in cash, 5.4 billion that is payable upon the effective date, which is August 29th, another 600 million in January of 2021, and then another 750 million in January of 2022. In terms of the stock, there are anti-dilution provisions that are built into the agreement. So while it could be as low as 20.9, because of these protections, it now is at 22.4. And I got an opinion from the TCC actually yesterday that explained exactly how it would work. Basically, what happens is you multiply the projected earnings times 14.9, which is a significant discount. Typically, the rate of earnings to stock is 17.33. So we're getting it at about a 20% discount. And the way that it works is we, and by we, I mean the trust, obviously no individual will receive stock, gets 22.4 or whatever is necessary to make sure that anti-dilution provision is respected. Currently, it's 22.4. That works out to 6.75 billion, and that's how the payment is made.
Would anyone like to respond to this notion that there is no discount in this settlement versus some of the others? Will?
Thank you. So part of what I think needs to be defined is what agreed means. So part of the problem that I see with this plan is while other stakeholders in this have signed agreements, much of this is still to be worked out. And part of this is a question of leverage. And so part of what my concern is that while other classes of claimants have negotiated cash and dates certain in terms of delivery of that cash, assuming the plan is approved, we are not. And so what that means is we're being asked to vote first and then get to the negotiation table about when and how much will be paid. And that does not sit well with me. There is no incentive for PG&E to be able to pay us soon. And to a large extent, they and other investors have signaled that they're going to be leveraging our trust and our money to buffer them to make sure that they're more protected over time. They have defined that we'll be paid over time. They have not committed to a date. The approximate date keeps being pushed back and pushed back and pushed back, particularly as they see additional risks coming our way, like wildfires, like additional fines and penalties from what PG&E does. So all of those things still need to be worked out. And I think that we need to make sure that those things are set so that we're actually voting on a plan as opposed to an aspirational 13.5 billion that isn't agreed to.
Well, thank you. I'd just like to respectfully respond to my friends, Will and Francis. First, with respect to the concept of the money being paid, this isn't some plan to be negotiated. This was a plan that was negotiated by the Tort Claims Committee and 13 fire claimant professionals and was signed in a restructure support agreement on December the 6th. And so now we're voting on a plan that's already been negotiated. It's not one open to future negotiation. There's not time. This is the plan. And the plan calls for $5.4 billion in cash. We're not getting paid after insurance companies, after the local government entities. This is not true. But what is happening is in addition to the $5.4 billion, we've got approximately $1.35 billion that we grabbed in addition to the cash in order to maximize that. With respect to the stock, Mr. Singleton was correct. There's a set percentage, there's anti-dilution provisions. I'll just talk about what the COVID-19 pandemic has done to the market. What it's done to this stock is it's gone up 24% since the day that we all signed the agreement. There's good reason to believe that will continue to happen. But more importantly, it's the best plan, not just because it's a good plan that pays people in 2020 and 21 as opposed to 2024 and 25. It's also the only plan. And if I could just respectfully, I do not believe that putting up on social media that there's this customer owned utility idea is really a fruitful use of our time for several reasons. Number one, they can't guarantee $13.5 billion in cash unless somebody's going to write that check. That takes financing to the tune of about $60 billion for somebody to take the equity out of this and pay all of the debts. That money does not exist. The one thing I can tell you is that when you look at what's happening in Sacramento, the legislature goes into session on May the 4th, perhaps. There's already a deadline that's passed. I think it was February the 21st for new bills to be filed. And I searched it today. There is no bill setting up a customer-owned plan, buying out the equities interest. It's not been filed, and the deadline's already been passed. I checked on everything that was filed by State Senator Jim Nielsen in Chico and Assemblyman Jim Gallagher in Chico. No bills from them with respect to the folks in Napa. Senator Bill Dodds hadn't filed this bill. Assemblyperson Jim Ward hadn't filed this bill. The folks over in Santa Rosa, Mike McGuire's not filing this bill. Jim Wood hasn't filed this bill. There is no bill available, and so there's not time.
Okay, I think this is an important point. And Bonnie, I saw your hand go up at the mention of there is no alternative plan. Did you want to respond to that?
Yes, thank you. I do want to respond because the reason there's no alternative plan right now is because the debtors have kept their exclusivity, and at this point in time, another plan cannot be filed. Now, the debtors could have opened this up, and that's been a criticism for several months. Why don't they open this up and allow another plan to come in? Because as the governor and many folks have pointed out, you have to have competition among these plans. So when people say, there's no other plan, we have to vote for this, that's not really giving anybody a choice. And that's what the debtors decided to do. No choices, no choices. Now, I do want to point out something very significant, and that is when we talk about this is the only plan, I want to point out that this RSA, the restructuring settlement agreement, was signed on December 6th under very different conditions. And the first and foremost was that the debtor amended it later on. So we don't have the same plan that we started with. And what they did was they added $3.7 billion more in debt, and they reduced the amount of new equity cash at the end of the bankruptcy from 12 billion to 9 billion. And both of these changes, these were changes to the plan. Some attorneys in court have called it a bait and switch plan. These changes in the plan have impacted the PG&E stock. One financial expert has filed declarations in court that it has reduced the stock value by at least 20%. Other attorneys in court stated it is more like 30% or more. So not only do we have a different plan, that change in the plan has reduced the stock value. And then furthermore, as we all know, the coronavirus tragedy is devaluing the survivor share even further with regard to the stock value. And another very important factor that PG&E will not move on and will not resolve is when can the trust sell the stock? They are required to agree under the RSA to a reasonable registration agreement as to when the stock can be sold by the victim's trust. And they have just absolutely refused to enter into that. And right now, as it stands, it's very possible the stock cannot be sold for 6 months. And prior to that 6-month time period, it's very likely that other stockholders, major stockholders, would be selling the shares quickly, and that's what they stated in court.
Okay, Mr. Singleton, I'm going to come to you, but I do want to move on to the next question. So if you could just keep it to 30 seconds or so, and then we can come back to this theme.
Sure. I think that's an important point. I think Bonnie raised a couple of things. One, she's right. Certainly the debtor could have opened it up, or if there were actually proponents of a COU plan, they could have filed a motion to terminate exclusivity. They didn't do that. So the bottom line is there's one plan and one plan only. And I concur with Mr. Watt's statement that I don't think it's a really good idea to tell people there's another plan when there simply isn't one. Bonnie's right, there's not. The other point, and I think this is critical, is that she's also absolutely right about this restructuring agreement and the reservation of rights agreement and how important that is. However, and this came out at the last hearing, what has to happen for that to get done is the underwriters have to be selected. PG&E has selected their underwriter. The TCC has had difficulty selecting theirs, not through any fault of their own. It's my understanding that they've been looking and there's been difficulty, but I do think, just to be fair, it's important to note, and this comes directly from the TCC, that they have not yet been able to select their underwriter, and that's why the reservation of rights agreement has not been agreed upon.
Okay. Very quick word from Fran, and then Jared will ask the next question.
If anybody who is tuned into this wants to see what the consumer-owned utility folks propose, get document number 306-1 that was filed in Judge Donato's court. And that number is 319 CV 05257-JD, and you can read it from the consumer-owned.
Okay.
That's not a plan. Lily, I'm sorry, but with all due respect, that's not a plan. That is a statement.
I didn't say it was a plan. I said it was a proposal.
In all due respect, part of this is all of these are not plans. So part of what needs to be defined is a restructuring support agreement, which you guys are referring to as a done deal, is a support agreement. And part of what needs to be understood is that is a framework. That is not the plan. That is not what we are voting on. What the plan is, what the significant things are that we're voting are still yet to be determined. The trust agreement, the registration rights agreement, and the plan. The RSA is a framework that is to set the stage for how negotiations will be through the bankruptcy process. So to represent that we have the money and that's the plan is wrong. And all of these plans are ready to go as soon as we let them come in. They're all negotiating amongst themselves, getting financing. They all have that ready to go if we provide that as an opportunity. There is no saying that this agreement in development is going to make it to any finish line faster than any of those others. And I just think to state that is disingenuous.
That's simply not true. I mean, the bottom line is I understand that you're not an attorney and I'm not in any way holding that against you, but the statements you made were not factually accurate. A plan in bankruptcy context has a very specific meaning. This plan, and I would ask Mr. Elias to come in as he is a professor, but a bankruptcy plan is very different than a proposal. Mr. Scarpullo is absolutely right. Several people have said it would be a wonderful thing if PG&E were converted to a consumer-owned utility, and that's a philosophical debate that absolutely can be had. But it's very different to have a philosophical debate and to have an actual plan. There is a plan submitted that has actual financing, and that is what we are voting on. The COU does not have financing. It has a statement saying that they would like to somehow obtain $59 billion in financing. And I'm reading exactly what Mr. Scarpullo referenced, and it is document 306, subsection 1. I would encourage everyone to take a look at it. There's not a single reference to who is going to be putting up this 59 billion plus that's going to be necessary. On the other hand, the actual plan, and again, this is a plan, it's on Prime Clerk, it can be accessed, it can be viewed. That plan has all of these different financial institutions, over 70, that are providing the financing that's necessary. So believe me, I understand what you're saying, that, and Bonnie made the same point. I'm sorry, what?
It's a draft plan.
It is not a draft plan. It is a plan that has been submitted. It has been approved by the bankruptcy court to be voted on by the creditors. That is the definition in bankruptcy of a plan. That's what the creditors have to vote on. And again, Professor Elias is here, and I would ask him to weigh in on this.
So I'm just going to steer this in a slightly different direction for a second. We'll get a little bit later to the question of alternatives to the current plan of your organization, which is what you are all currently voting on. You're voting yes or no on the plan of your organization that the company is proposing. And one of the controversial aspects that we've seen in the chat so far is that the plan of your organization contemplates creating a wildfire trust fund, which I recognize from the chat that not everybody fully understands. The wildfire trust fund is going to have $5.4 billion in cash, about $1.35 billion that'll be filled out later by PG&E, promises that will come in the future in January of 2021 and 2022, and then also $6.5 billion in stock. So what that means is that of the money that is being put in the pot, the value that the company is going to place into this trust fund, which will then be used to pay all of the claimants of the various fires against PG&E, $6.5 billion of those dollars are, post-bankruptcy stock in the reorganized company. And one of the questions from chat is from Tom Saltamalachi. I'm sorry for mangling your name, sir. I appreciate you participating. Why are they sure that it, meaning the stock, is going to be worth anything with a worldwide pandemic and our stock market as it is today? So I thought that'd be a good question for folks to respond to. Would anybody, Mikal?
Sure, it's Michael. Look, we got both cash and stock, as Jerry said, because we weren't willing to take the discount. So we took all the cash that was available, all the cash that they can raise through an equity offering, and got that put into the trust, including future cash streams. So we took everything. But in addition to that, we told the equity holders, in order to ensure that our folks are fully compensated, we want a percentage of ownership of the company. Now, there's been a lot of disinformation from the standpoint of that people are going to be required to take stock from PG&E as part of their settlement. That's just not true. What's happening is that stock right now, today, there were phone calls between the TCC members and the equity and the investment bankers with respect to negotiating this rights agreement that should be done within a week or so. I agree with Jerry that the delay has not been anybody intentionally doing it or some draconian idea, but the stock itself is this. If you look at where this stock traded before the 2017 fires over a 5-year period of time, it's right there on Yahoo Finance. It traded at much higher multiples. And so what you have to look at is, what are the things weighing down old PG&E that new PG&E will not be weighed down with after exit from bankruptcy? Old PG&E has $19.5 billion in claims from insurance companies. Old PG&E has tens of millions of dollars in credit claims from the bondholders. Old PG&E has tens of billions of dollars with respect to fire claims. There's all sorts of things weighting it down, but most importantly, old PG&E is subject to the California law with respect to inverse condemnation, and so it bears the financial risk of future wildfires. Once it exits, because of AB 1054, and it must exit by June 30th. My biggest problem is that Bonnie just admitted there is no other plan at this time. Fran just said it's a proposal, not a plan, but we're out of time. There is no time to put together another plan. document number 306 was put out as a nice idea in September. We were having a bake-off with respect to the bondholders and the equity and this customer-owned utility plan. And everybody unanimously on the TCC at the time, and 13 consenting fire claimant professionals that represent about 2/3 of all the claimants, unanimously voted in favor of the equity plan. Now, why is that important? Because if we miss the June 30th deadline by voting no, AB 1054, this $20.5 billion risk pool goes away. And there will be nobody that will put up $60 billion to finance the takeout of this company, because they won't have access to the risk pool to make it a bankable or a tradable stock because of this risk of future wildfires. And then the other thing I would say in ending it, and that is the plan changed for a very specific reason. We weren't the only ones with whom the equity participants had to negotiate. Why? Governor Gavin Newsom's office had a lever, and that is that his California Public Utilities Commission had to certify that this new plan is AB 1054 compliant. And so there were all sorts of concessions that were negotiated by the governor's office from the equity to make them put more money into grid hardening, so you reduce the wildfire risk in the future, to do it in a way that the company doesn't take on too much debt, and most importantly for a lot of people, in a way that's as rate neutral as possible. So those changes to the plan were dictated by the governor's office in order for him to approve and make it AB 1054 compliant. So what you have now is you have an idea that was put out in September, document number 306. Wouldn't this be grand? Nobody put up $60 billion to fund it. In the spring of 2020, nobody is putting up $60 billion to fund it. Nobody can fund it without a state backstop, and there's no law, there's no bill to provide that backstop. And with the budgetary crisis we're in the middle of, it's just not feasible.
Okay, the couple things there I'd like for panelists to address. We've talked about how the initial agreement was formulated in early December. Obviously, much has changed since then. One of the things that's changed is that PG&E is now planning to take on more debt than was the case then. So if anybody wants to address that, that would be welcome. I also want to bring a question. I'm going to clean the language up, frankly, that's in the chat, but it's from Josh Garrison, and he's asking why Mr. Watts is promoting this plan as being supported by the tort committee. When that's not true. And so let me just kind of come back to that question, because in the last month, we have seen 3 of the 11 members of the official tort claimants committee in this bankruptcy resign from the committee. We have 2 of the lawyers representing the members who resigned. And if either of you can speak to what happened there, I think that might be illuminating for folks.
We have to be very careful, because as former members of that committee, we are bound not to disclose anything that occurred in the committee that was not a public record. So
you're not allowed to say the goings on of that committee under the documents that you signed or that were provided to you by your counsel. Is that correct?
No, it's in the bylaws of the committee. And the committee members are prohibited from discussing anything that occurred in the committee that is not a matter of public record. So we can respond to you, but only in a very limited way with only those facts which are currently in the public record.
So why don't we ask the very simple question, why did your client resign? Can you say that? Can you answer that question?
Well, yes, because we sent a letter to the trustee because they could no longer support the PG&E proposal because it didn't provide $13.5 billion in consideration to the class members, and they thought there was a better deal out there, and there is.
Okay, go ahead, Jerry.
Yeah, I just wanted to address, I believe it was Josh's point. To address what Michael's point was, his statement was at the time the deal was signed, all 11 members unanimously supported it, which is true. Now, I understand at this point, 3 people have dropped off and do not support it, and that's understandable. But to address the larger issue, which is I think the one you raised about additional debt being added, that's where the anti-dilution provisions come in. And that's why, although the initial RSA, the restructuring support agreement, was for 20.9, it's now been increased and it's at 22.4. And the ultimate number is going to be between 22.4 and 23.5, depending upon a variety of factors. So that's how that issue was addressed.
May I just say one thing? The tort committee did not unanimously approve or sign the RSA. 4 members of that committee refused to sign it. My client and I were one of them.
That all I can say is what we were told by TCC's counsel. I wasn't in the room, so I don't know, but certainly it was represented to us that all 11. But again, I just want to ask Mr. Scarpula to clarify, when you say there's a better plan out there, you've acknowledged that the COU is not a plan. There's only one plan that's been put forward in the bankruptcy court and is being voted on. What is that other plan?
You call these things plan. I don't call anything a plan. There's a proposal out there from the customer-owned utility group that they think they can do this before 30th, and that they have funding for it, and that they can put the money, $13.5 billion in cash, in the bank on or before September 30th, 2020.
Well, here's the problem with that, is the process is supposed to be transparent. The current plan lays out all the financing and it allows the victims to look at it. What you're proposing is, even though these people didn't file a plan, which the document you say specifically says that they should go to the court and ask for file a motion with the bankruptcy court seeking authorization to file a competing plan. That's in the document that you asked everybody to look at. They didn't do that. So they haven't done a plan. And again, a plan is a term of art in bankruptcy. There is absolutely nothing in this which identifies a single financial entity that is going to fund this. So the problem I have is going to my clients and saying, on the one hand, we have a plan where we know what the financing is. We believe it's going to result in 13.5 billion or greater, but we have to tell you 6.75 billion in stock, could be more, could be less. There's no way to be sure. But what you're proposing is there's no plan, but somehow 59 they should say who's going to be putting up that money so that the victims would know whether or not it's real or whether it's pie in the sky.
Well, that's something that the customer-owned utility group can tell you, because I understand that they do have one or more banks that is ready to fund it.
Well, then they need to do that. But the thing is, I've asked you for that information. I've asked them. I've contacted Mayor Licurdo. No one has said who is going to fund this. And I think that they owe that to the victims.
Because they're precluded.
Wait.
No, they're not.
I'm not suggesting.
Okay, let's do.
You have a number of clients that are affected by this. We're not suggesting that people vote no or that they vote yes. They don't have to do that right now. They can wait for a couple of weeks at least to see what happens. That's the suggestion. There's no reason to have any vote immediately, is there?
But Fran, if it takes $60 billion and we don't even know the name of this supposed bank or group of banks that's going to put it up, so the vote ends on May 15. There's nothing in the legislature for a state backstop for this customer-owned plan, which nobody's ever going to put up money without the state backstop. So you need legislation. Nobody's filed it by the deadline. It's an impossibility for $60 billion to appear out of thin air for a competing plan that never can meet the June 30th AB 1054 deadline. You can't get it done in time. And the point is this, that the time for competing plans was back in September when 306 was offered. And everybody said, well, that sounds like an intriguing idea. Put up the money, show me the money. And nobody did that. And then the bondholders versus the equity, they showed their wares, and there was a selection of the equity, but I don't even know the bank involved that's saying, hey, I can round up a spare $60 billion without a state backstop. That's not, I guess what I'm saying is hope is not a plan. And,
okay.
and there is not money.
I'm going to have Bonnie step in. We had a previous theme that we were on, and she's had her hand up for a little while. Go ahead, Bonnie.
Oh, thank you. Yeah, you know, this, I don't want to call it a plan, but you know, the mayor of San Jose, Sam Liccardo, I think you misspoke there earlier, Jerry. Sam Liccardo has written about this and this was in the end of February, where he had put together a consortium of 195 municipalities and other government entities to be part of a COU. Now, we don't, you know, I don't pretend to know what the COU would be proposing in terms of funding, et cetera, but there has been a lot of discussion out there. And I'd also point out that Mayor Liccardo was very fearful about the stock. He said, when this bankruptcy is over, he said, basically, they're going to have, first of all, they're saddling the families that have been dealt this terrible, tragic blow by these fires with the risk of future wildfires. And that's very true right now, because the stock, if there are future wildfires, we know the stock is going to go down drastically. Now, we also know that there are people talking about, excuse me, Jerry, just let me finish. We also
absolutely. I was just letting Lily know I wanted to speak when you were done.
Oh, you were waving. Okay.
Yeah, I'm sorry. Yeah, go ahead.
No, but they really anticipate a much greater risk of wildfires this wildfire season. And we know that the Tort Victims Trust the Fire Victims Trust probably will not be allowed to sell their stock for a minimum of 6 months, because PG&E, and you could talk about whose fault it is, but they've had 4 months or longer than that actually to put together the stock agreement as to when it can be sold. Stock registration agreement. I think, Jerry, you mentioned it was a registration agreement or something later, but I think you misspoke. But in any event, they've had a long time to put that together. They're required to put it together. In the first restructuring settlement agreement, they were required to put it together. In the amended one, they're required to put it together. But I do want to point out that Mayor Liccardo said, look, basically they're going to have, PG&E is going to have, and this is before the coronavirus roiling of the market, they're going to have a junk level credit rating. And so again, the stock is not going to be worth what everybody claims it's worth. It's not going to be, because of the amendment to the plan, the unilateral amendment to the plan. And I just want to point out that we did not sign the RSA back in December. It wasn't signed by all the members of the Tort Committee, personal counsel. It wasn't signed by all the Tort Committee members. But that's another story. And that's a matter of record, Jerry. You can go back and look at that. But the point here is that Luzardo's pointing out and relying on economists, et cetera, saying, look, they're going to have a junk level credit rating. And we've got the fires coming up this season, and they're going to be worse than they were in 2018. It was horrible.
Well, I'm sorry, go ahead.
There is discussion of a proposal out there that cannot be put before the court right now because of the exclusivity. And all PG&E has to do is just say, okay, we're not going to insist on exclusivity. They don't have to insist on it. They wanted to so that the fire victims would not have a real vote. They've either got this wretched plan, which is not going to work, or nothing. And what my client, Ms. Goins, was terribly concerned about was that they were going to end up with very little or nothing. And that's the way it looks right now with regard to half of the funding on this. Now, I always say, you want to find out what's going on, you always follow the money, follow the money. And
Great,
yeah.
So speaking of that, Bonnie, if you don't mind, I'd like to pose this question to the group. And this is the last question we'll get to on the value of the stock. And then we're going to move on to some other aspects that are really hot in the chat. But this is from Linda Knight, who said, stop the bickering about plans and get to more fundamental questions. For example, what assurances are there that the sales of the stock, right? Because remember, it's not that $6.5 billion in stock will be put into the trust. It's a pot of stock that is valued under the plan at $6.5 billion, and that may be the value of it, and that may not be. And it may be that that pot of stock, it'll be some number of shares, is worth more than 6.5 billion, and maybe that it's worth less. So Linda's question is, what assurances are there that the sales of that stock over time will result in the promised $6.5 billion number? And let's see, does anybody want to take this? I see Michael.
Sure. So here's the issue. The stock is going to be supplied to the trust. This is not going to be something where Michael Watts or Bonnie Kane or Fran Scarpula are going to decide when to sell stock. This is way above our pay grade. So some of the best investment banking firms in the world are being interviewed at this very point. And so they will advise the trust with respect to the best way to liquidate the stock to turn it into cash with which we can pay claims. They're advising us that, look, if out of some fear that you wanted to get rid of all the stock before the fire season, you could dump a bunch of stock and decrease its value, but we won't have to do that because we'll have the protection of AB 1054 and the $20.5 billion in insurance that'll be available to PG&E if some of its equipment starts it. So that's number one. Number two, you have the secondary advantage that if you do hold the stock until about January of 2021, this was the way this was structured, we'll have $5.4 billion in cash to begin paying claims. Then the stock will be in January of 2021. We already know what the expected earnings of this company are. This is a utility that has very predictable earnings because, frankly, it's got 17 million customers sending it income on a basic monthly basis. And so it's something that the market can look at, and they'll trade it based on 2022 earnings, and that's where the stock could do very well. So the real risk on the stock is this. If for some reason you think that there's going to be a fire that causes more than $20.5 billion in damage, and I would remind you that all these fires are being settled for 13.5, so I just don't think that's going to be likely, then AB 1054 is going to protect us while the price of this stock is continuing to be optimized by investment bankers that nobody on this panel is going to be involved with from the standpoint of how to sell it.
Yeah.
All right, Will?
Thank you. First of all, this is not 13.5. That's just the victims part of the settlement. This is much larger than that, first. Second of all, we should understand when folks explain that don't worry, you don't have to hold the stock, it's going to be in a trust. They position that as if that's a good thing. If you had the stock yourself, you could buy and sell that as you please, based on what you think the market will do and how you think, when you need cash if you're rebuilding your home, or if you want to hold for a longer term investment. That's what you would be able to do. The trust, regardless of how good it is, and if we vote now and then negotiate the trust, it won't be very good at all. But the trust itself is going to put restrictions on that. It's going to tell you when you need to hold the stock, when you can sell the stock. And those things need to be negotiated with the debtor, PG&E. And they are in a position where they want to make sure, as they've stated under my cross-examination of them at the CPUC, that is held. Mr. Johnson, the CEO of PG&E, stated unequivocally His expectation is upon exit of bankruptcy, the hedge funds will exit the stock. He is hopeful that traditional utility investors he'll be able to attract. So traditionally, utilities have been safe. I don't think there's anyone out there that thinks PG&E is safe right now. And so you are not going to be able to attract those traditional investors. And then they're going to go to ratepayers and they're going to say, look, we haven't been able to attract the funds we need. We're going to raise rates. And we'll see what happens there. None of this is assured. And if we, and so we need to make sure that's, and if you think this is transparent, I ask everyone to please read the 7 pages of the restructuring support agreement and see all the exclusions and how it locks out competition, how it shuts the mouths of attorneys for representing anything against the plan, and then make a determination if you think this is an open process.
I want to go to Gerald, but just in transitioning, I'd like for you to address the issue of, utilities are often seen as a safe investment for people on a fixed income. That's really up for question in this scenario where you have a utility that's not going to be paying dividends for 3 years.
Right. Well, and I think that addresses something that Bonnie and Michael said. Bonnie and Will both expressed concerns that are certainly legitimate, and a lot of people have said, what happens if there's another fire? But that gets to Michael's point as to why it's so important for PG&E to get out of bankruptcy by June 30th. If they get out of bankruptcy by June 30th, then they have access to AB 1054. AB 1054 set up a $21 billion insurance fund, and that insulates PG&E from bankruptcy. That's what it was designed to do. What happened is last year, the legislature was looking at it, and they were faced with the decision, do we take over PG&E and run it as a municipality, or do we give it some type of insulation from future fire claims? And what they decided to do was to come up with AB 1054, and it created this $21 billion fund. What that does is it essentially insulates them from bankruptcy. There's never been a fire, a single fire, that resulted in anywhere close to that amount of damages. I certainly understand what Mr. Abrams was saying when he said, this isn't just 13.5, it's also the 19.5 from Subro and the 1 billion from the local utility or the local governmental entities, but that's 24 fires. If we're talking about a single fire, we're looking at something like Kincaid, which is going to cost probably in the $400 to $500 million range. PG&E can pay for that with their insurance. So the whole idea behind AB 1054 was that PG&E would be insulated from bankruptcy from future fires. And then the stock is going to go up because it's going to be similar to the typical type of utility, like you're saying. It's certainly true that they can't pay dividends for the first 3 years, which I think is great. They've paid out enough dividends, and it's time for them to put that money into hardening the system, which is something they've committed to do. But when you look at the profile of PG&E, if they emerge from bankruptcy, what they are going to be is a typical utility that does not have to worry about bankruptcy from fires. As a result, they're going to be very attractive to investors. And that's why most investors are thinking this stock is going to go up. Certainly, coronavirus has thrown a monkey wrench in everything. Obviously, all stocks have gone down. Certainly, we all hope they come back up. But if you look at what PG&E's done since we signed the agreement, it's gone up 24%. And I think that speaks volumes. The final thing that I think it's very important to say, and I know this is something that Mr. Abrams has said before, and again, respectfully, it's simply not accurate. We have an absolute duty to tell our clients the truth. We have a fiduciary duty, and we've said that. We have said what the negative aspects of this plan are, which is that the stock is not guaranteed. It's absolutely not. However, I just think that's important, and that is something that I think it's important to get out there.
Sure, thank you for that. And I acknowledge that this is an incredibly volatile stock, and you can pull all kinds of percentages. I mean, if you look at where the stock is valued today versus mid-February, for example, it's lost half of its value. Those numbers are going to fluctuate wildly if you look at the difference from December 9th to today. So I just want to point that out. Does Bonnie or Fran, both of you have had your hands up in the air. If you want to just briefly respond to that, and then we'll move on to the next subject area.
I just wanted to say one thing about the wildfire fund. That's not 100%. They only can take 40% of it. And
That's not correct.
I'm sorry, but that's what AB 450 says.
That's not what it says. It
That's-
says they pay 40%.
Well, there's no reason to argue about
access
what
to
it
it.
says. All we have to
Okay.
do is get it out and look at it.
That's true.
But the other thing is, it costs them 4.5 billion in cash to put into that fund, right?
I think it was more like 6. I think they had to pay close to 60%, but yes.
Okay, so they put in 6 billion. Where's that coming from?
That came from PG&E.
The equity raise.
Yeah,
I've
That
had
was
your hand up a long time.
right.
right. Yeah.
Right. So I think at this point, wait, Bonnie, did you have a comment?
Well, just basically the same as Fran's. The wildfire fund is for the under 1054 is for the entire state. It's for all the utilities. And furthermore, my understanding, like Fran's, is that it only covers 40%. So it's not going to be a wonderful savior to the stock price. This coming fire season. This is a very, very, very serious issue. And what I have not seen from anybody on the side saying, hey, vote for the plan. I have not seen any economist, I have not seen any expert say the stock is going to be golden, because it's not. The only experts and economists that have spoken on this issue said, no, it's going to be, it's already lost 20%. It's going to go down to 30, 40%. And so, and my question in all of this, and this is not, and I want to respond to something Jerry said at the very beginning, the victims didn't have to take stock. They didn't have to. And my question to you all today is why are these wildfire victims who have been victimized over and over and over again? They've been victimized by the out-of-town contractors coming in and overcharging. They've been victimized by out-of-town attorneys even. They've been victimized by everybody. Why do they have to sit at the bottom of this bankruptcy, and especially when they've had to watch their loved ones die, they've had to watch their homes burn up? Do you think any of those fire victims want to take stock in a company that is so mismanaged that they, even though it's held in a trust, they will be basically the stockholders in a company that will wreak havoc and cause other people's loved ones to die and other homes to go under? Do you think they want to hold that stock? No, and they didn't have to. And I want to go back to the subro issue. As I said, it was brought up very early. There's a lot of questions about the insurance carriers who are getting those subrogation rights. First of all, in California, they're not entitled to those rights at all until the victims have been made whole. But here, it was finagled to pay them first or at the same time at least, but they're getting all cash. Now, one of the, and I will say this again, it was very questionable about their numbers as to what they threw in there, because we're told, oh, they took a big discount. Well, they didn't take a big discount. They put numbers in there that were for reserves that were never paid out. And further, they sold. We're told that they, at this point in time, they have sold over $9 billion of those insurance claims to, guess what? Equity holders. So you had people, there was no negotiation on that 11 billion. It was the same company negotiating with each other. Oh, let's take 11 billion in cash. Now that isn't fair. And it's not fair to put the fire victims, they're the only group of people in this entire bankruptcy that are being forced to take stock. And now we find out that the plan was changed, and it was unilaterally changed, which is devalue the stock.
All right,
Okay.
so Bonnie, sorry. So we need to pivot away from the question of the value of the stock. So thus far, we've focused a lot of our discussion on the stock portion of the Wildfire Trust. And again, $13.5 billion in value under the plan. You know, there are arguments about whether or not it's actually $13.5 billion in value, because perhaps the stock isn't worth as much as, you know, that has been represented, and you've heard those discussions already. However, we have questions about the $13.5 billion number that is being used. And this is from Richard. If most fire survivors submitted claims with the dollar number amount unknown, how was the $13.5 billion number determined? Where did you come up with that headline number, and where does the confidence come from that that's the right number for everybody?
Sure.
Michael?
Sure. The $13.5 billion number came up pursuant to a tentative deal between the Tort Claims Committee and the bondholders. And so what happened is that the equity came in and matched it and had superior, issues. They had real money. The other guys were talking about having money, and money in the hand is worth a heck of a lot more than some idea that hasn't raised the capital. I just saw a Business Journal article about this customer-owned utility idea from the Mayor Liccardo. It says they haven't filed any paperwork, named any directors, raised the capital for the bid to be considered by the bankruptcy court. It's just an idea. It's not a plan. But to get your point with respect to the 13.5, the 13.5 was heavily negotiated from the standpoint of not only the 5.4 that they could get, the 1.3, we made them back it up with respect to 70 of the largest financial institutions in the United States, providing $12 billion in financial backstops, because we didn't want to take the risk that that income stream was in any way contingent, and it's not. It's backed up by all sorts of backstop partners.
Sorry, Will?
Thank you. I want to clarify something. I think that's an excellent question. The answer is there is no range of settlement. So traditionally, as it's been explained to me with a bankruptcy proceeding, in the disclosure statement, it would provide a range of settlement, maybe on a square foot basis for your home, maybe related to the type of claim that you're seeking. That was not included. The debtor stated in the hearing that they've done their own analysis, so PG&E has done that analysis, but they have not made it available to you. Additionally, the liquidation analysis for if there's a fire, or if PG&E is discovered to have more transgressions, or if the hedge funds leave the stock and we can't attract new investors and PG&E goes south and we're left holding the stock, or we haven't been paid in our cash, what occurs? None of those things have been spelled out to us. And I hope that the plan improves. And as we get close to that May 15 date, that those things get determined. So you don't have to guess as to what that would be. And I think nobody has to tell a wildfire survivor the risks associated with PG&E and that investment. I think everybody knows that firsthand.
Great. Fran, I saw you with your hand up. Fran, you're on mute.
Fran, you're still on mute.
Fran, you're still muted. All right. Fran is having some. Fran, can you unmute?
Everything.
Fran.
Now I'm back. I lost the picture. I lost. Now it just came back. Okay, so look, I know exactly how the bondholders' plan or proposal got to the TCC, because I got it from them and brought it to the TCC with Jerry Hallison and Rafi Balabanian. We put that together, 13.5 billion all cash. At the end, during the negotiations, the PG&E proposal was much less. We got the bondholders to go up. PG&E went up. We got the bondholders to eventually go to 13.5 billion. PG&E matched it. And the reason that the PG&E proposal RSA was signed was because PG&E could do two things that the bondholders couldn't. PG&E could settle the Tubbs preference claims, which were then pending in the Superior Court because the TCC had requested that certain Tubbs claims be sent over there for a trial. And they could also then avoid the estimation hearing and trial. That's why the PG&E plan was accepted over the bondholder plan, which eventually offered 13.5 billion all cash to the fire victims, plus 150 million to the ghost ship fire claimants. Plus, they would have paid all of the public entity claims except FEMA and Cal Office of Emergency Services, which I think they would have paid in any event. So, but that plan was never permitted to go forward. That proposal was never permitted to go forward, even though the bondholders were at the mediation. Judge Newsom wouldn't even let them in the room. That's I'm sorry, that's not Governor, any relation to Governor Newsom. It's Judge
Right.
Newsom with an E on the end.
Judge Newsom, the mediator in the case. Michael and Jerry, both of you have your hands.
So
One of you
that's the way
take a stab at that. What were some of the misgivings about the bondholder plan? It was a big deal when Judge Montali allowed an alternate plan option, and proponents of the current settlement will say that was really key to helping expand the pie in this case. That's what they would say anyway.
I never understood the problem.
They're absolutely right. It was key, and they did a great job in getting that bondholder plan. Couple of, I think, misstatements there. One is that, as you said, Lily, they were allowed to present their plan, and it was offered. It was never 13.5 billion in cash. It was a mix, and that was why the PG&E current plan is a mix between cash and stock. The bondholders never offered cash. That's a misnomer.
Fran, do you want to address
Absolutely
that?
did. They absolutely did. You just haven't seen it.
They didn't.
I'm telling you, I have the piece of paper.
Okay.
They sent the TCC.
They never said a plan which had 13.5 billion in backing. When they said they were, I mean, that is true. When they
let's
said,
not fool around with these terms, plan and all that stuff. They made a proposal.
A plan is something that actually has funding and is backed up. That never happened. What they said is,
you're talking about people here who've got trillions of dollars in assets. They had the money.
Not according to them, they didn't. But anyway,
I'm going to jump
Michael,
in
you're
here
on.
because
You're on mute.
I'm getting a lot of questions. Both of us, Jared and myself, are getting a lot of questions in the chat. I think people want some answers to, the now questions, such as, why should I vote yes on a plan that has some open questions, including, what is the actual amount? Is it 13.5 billion? I mean, we report it as such, but there has been some financial analysis in recent weeks that would question that amount. And also the timing, when will I get my money? And am I going to have to wait one or possibly even 2 fire seasons to get my money to help rebuild or, move out of the area and find another place somewhere else?
So let me answer
this.
Yeah, let me answer the second question. One of the good things that's been happening since the equity plan was chosen, and this was a thing that came up in court yesterday. The court kind of tentatively appointed a gentleman by the name of Justice Jack Trotter to be the trustee of the trust. He had distributed a bunch of the money in the 2006 San Diego fires and apparently done a great job, and everybody was for him. and then Kathy Yanni, who administered the $105 million wildfire assistance program after these fires. And so she was selected as the claims administrator. Those two individuals have convened a large number of folks to, in effect, work on claims rules for different kinds of cases. And so we're very far along with respect to, if you have a wrongful death case, what do you have to do? If your house burned down, you have a structural loss, what do you have to do? What do you have to do if you're claiming personal property loss? If your trees or forestry, burned down in the fire, how do you recover from that? Or if you just, escaped from a 50-foot wall of fire, the good Lord didn't wire us that way. And so there's psychological, mental anguish claims that people will have, lost income claims, business claims. All of that work has been working on for the last 4 months, and we're very far along. And now that Trotter and Yanni have been formally appointed with a budget, they're hiring up a whole bunch of people. And so to answer the question about how long it will take, the goal is that because so much spade work has already been done, and because you've got to give people an amount of time to file their claim while people are in the claims filing period, we're going to have hundreds of people analyzing those claims immediately. But I've talked to Justice Trotter and I've talked to Kathy Yanni. The goal is to push out a significant amount of this money in 2020, with the remainder being pushed out in 2021 and just a little bit left in 2022 from that last tranche of cash. So the idea is to write up the claims rules, to get them out there, to get people started getting their claims in while the stock is being liquidated, so that we hit the ground running at the end of the year, getting rid of a lot of this cash, and then when we sell the stock, getting rid of the rest of it in 2021.
Will?
Thank you. I think that's a great list from Michael in terms of the things that are still outstanding. And that's why it absolutely makes 0 sense to vote on this plan now and then negotiate it later. That would be like turning to someone and saying, hey, I'd like you to give me some money. We'll work out what that is, but we're going to agree to this deal and then work out the sum. Then we'll work out the rules about when you get the money after you vote. That makes absolutely no sense to anyone. Why on earth you would advise vote first and then negotiate the terms of the stock and the cash and all of those things after makes 0 sense. Why not empower the TCC to say, look, we've told our clients to hold off until May 15th to give you time to get this done with PG&E. That's what we should be doing. We should be asking them to make sure that we understand exactly dates and dollars to a level of specificity where we can actually cast a vote on something rather than aspirational, you might get some money at some time.
Jerry,
for somebody who's in favor.
Hold on, let me go to Jerry on that, because he was a very vocal, he was a voice that spoke directly to this with Judge Montali during a hearing last week. And he also filed a court brief to this point about, the TCC essentially, which Mr. Scarpula and Ms. Kane at one point represented members of, who resigned, saying that they don't represent fire survivors in this process. They don't represent the majority of fire survivors, I believe was the exact language. So if you could just respond to that and sort of why there was pushback against, what was seen as, frankly, a pretty, a big ask on the part of the TCC to pause voting while these details were still being worked out, pausing it till May 1st to see if they could get traction in negotiation.
Sure. Just to address Mr. Abrams' point, there's a couple of things there. One is something that needs to be negotiated with PG&E, and that's the reservation of rights agreement. And that's something that is an underwriting deal, and that's going to govern not just when the trust can sell its stock, but when all large shareholders can sell their stock. But the other thing that he's talking about in terms of when individuals are going to get paid and how they're going to get paid, PG&E has absolutely nothing to do with that. That is entirely determined by the claims administration procedures, and that's being set up by Justice Trotter and Kathy Yanni. That's what Michael was talking about. They've worked very hard. We've all been involved with them. Bonnie's been there, Fran's been there, Michael's been there, I've been there, and we've gone through these claims procedures based upon other fires. So that's how that process is going to work.
But it's not set yet, right? Jerry,
What's
it's
that?
not set. It's not.
No, it's absolutely not. It's going to take another few months. But again, it's not PG&E that's doing that. It's Justice Trotter and Kathy. And again, we know what the basic parameters are going to be. But addressing your point, Lily, and then I wanted to address the question that the initial caller had asked about what the alternative to this is. In terms of the TCC, they've certainly worked very hard. We've worked very closely with them. We just did want to point out that the attorneys on the TCC represent, 4,000 to 5,000 people. Those of us in the fire claim consenting professionals, which Michael and I are both members of, we represent over 50,000. So we do represent a lot more. And I think it is important that while we work together, sometimes there are differences of opinion, and this is where we had one. But addressing fundamentally what the question was, which is what happens if this isn't approved and what are the alternatives? The court has already approved a contingency plan. That happened last week. And what the plan calls for is for PG&E to be sold off by a transition officer. That could be as quick as 2 years, or it could take as long as 4 years. But what's very important to remember is that when that happens, it's going to be a sale of bankruptcy assets, so they're going to be sold at a discount. So in all likelihood, what's going to happen is 2 to 4 years from now, if this plan is not successful, there's going to be a pot of money, and then the victims are going to be paid out of that. In all likelihood, they'll get substantially less than they would get now, although that's unknowable. The only thing that we do know is under the current plan, we're looking at payment sometime, hopefully this year or at the latest next year. If this plan does not go through and there is a sell-off as the contingency plan calls for, it'll be at least 2 years, probably longer, and it'll probably be a greater discount.
All right. Bonnie, would you like to close us off on this topic?
Okay, now I've lost which topic we're on. I'm sorry. I did want to speak to some of these issues. First of all, the original RSA, which was signed on December 6th, called for a date, and we're talking about when do people get paid, right? And I think Jerry said, hey, it's not up to us. It's up to the trustee of the trust and the claims administrator. And they are very honorable, great people, and they have a lot of experience. But they can't do anything. They can't pay anything, Jerry. I hate to tell you that, until there is money put into the trust. And the original RSA said, okay, this has to be funded by August 29. And then they was changed to December 31, and PG&E has been asked repeatedly, when will you fund? And there has been no response. So we don't know when that money will go into the trust, the half of the payout. And I think that Will probably knows more than I do on this subject, but anyway, I did want to say that, first of all.
There's one critical thing. The RSA still says August 29th. It absolutely does. If you don't believe me, look on Prime Clerk. It's right there. It says August 29th. There's no question about it.
And the RSA,
Go ahead, Will.
Sorry, Bonnie. Did you want to? Okay. So this is an important point. The RSA is not what we're voting on.
No.
The RSA is a support agreement. And so it is a target. This is what we have in mind as we negotiate. The debtors have already tried to push that out, December, maybe later. Let's see how the vote comes in, and then we'll establish that date. Another point. Jason Wells, the CFO of PG&E Corporation, indicated specifically under cross-examination, it is his intention to make sure that that is paid over time, because he does not want a dump of the stock. So when the risks happen, wherever they come from, his intentions, and he has a say in this, his intentions are that the trust cannot dump the stock. They can't sell when they want to. They're going to have to hold it when other shareholders who don't have their stock in a trust can sell. And that is a problem. And we just need to give them time to make sure that those things are set before our vote. It doesn't matter how wonderful, and I agree, these are good people who are going to be put in front of the trust. By the way, there's a huge administration fee associated with this, which was discussed today. But that aside, and that's coming out of our trust, by the way, but that aside, it doesn't matter how wonderful those folks are, and those folks that have been identified are not CFAs, financial analysts, but they will do a good job, but they're not Houdini. They are not going to be able to negotiate rules with the debtors post-vote. And I think that's pretty obvious.
Yeah, and again, it's important to understand that no one's asking them to negotiate with the debtors. The funding comes in, and then they're the ones that decide what the individuals get paid. What's important to remember here is this: under the terms of the plan, which you're correct, is what we're voting on, not the RSA, if it's not funded by August 29th, then the individuals have the right to withdraw. So Will, you shake your head, but that's exactly what it says. So please look at it. That's what it says. The individuals can withdraw if the funding does not happen on August 29th. That's in the deal. Again, please look at it.
All right, so I'd like to pivot to some more discussions of the voting process, since that's what everyone is currently engaged in. And again, we're voting on the plan that's on the table. And this question is from Eric. And Eric writes, is it appropriate and ethical to have someone else cast my vote for me? I ask this question because my attorney is asking to get my permission to cast my vote for me. Right, Michael, would you like to start?
Sure. The voting plan was, there was an election done in effect of how you submit the votes, and different people could check different ones and like that. But I can assure you that every attorney that is collecting the votes has backup. This is a very high dollar process from the standpoint of that people are going to check and make sure that you've got the records of who voted and who didn't. And the last thing anybody wants to do is to supply information that is not true. Secondly, with respect to the process that was approved, there were 5 different options with respect to how to collect the votes and to submit them in, but there's going to be backup documentation with respect to every single vote that's cast. And if somebody doesn't have it, that's a bad idea. This is going to be subject to verification. It's going to be subject to procedures so we can make certain that the requirements of the bankruptcy code, which says that 2/3 of the holders of the value of the plan have to vote for it, that's in fact being met. I can tell you that that vote and that documentation is being collected, and I would suspect that every single lawyer on this panel is making certain that their panel, that their clients are fully informed. For example, we talked about this letter that was wanted to be sent out. I sent it to all my clients, even though the court said you don't have to send it out. You want to fully inform your clients. You want to collect the votes in a documented way and count them correctly, because any vote is going to be subject to being looked at to ensure that it's accurate.
All right, Fran?
The answer to the question is that the client should make the decision and vote, whether the client does it directly or whether the client directs the lawyer to vote the way the client wants.
I agree with Francis.
The lawyers vote, as Michael has been saying. I told each one of my clients, it's up to them how to vote. These are the facts, and this is the issues that you need to decide. And it's your vote, not mine.
I agree with every word he just said.
All right, William?
Thanks. I think this is really important, this voting process, because there's a lot of differences in terms of how attorneys are asking for votes. So there are certain attorneys that are sending robocall after robocall, sending text messages, check this box, make it easy for you, right? And then there are other attorneys that are waiting to provide a fuller picture of the information. And I think just, I would ask everyone to look at the information and make sure that they're coming to their own conclusions There's reasons behind why all of those practices are put forward. And certainly part of the argument from the folks that are sending those early notices is, oh, we want you to have a part of the democratic process. But, you know, part of this democratic process is getting information to be able to inform your vote. And so I would ask you to really make sure you're considering all the information, all the sources of that information before you vote.
Yeah, and William, I agree with that. I mean, our job is to get out as much information as we can. And, you know, it's kind of a challenging thing, right? We've done 24 physical town hall meetings with 600-700 people, and that was the intent. But the bottom line is that the shelter at home orders kind of prevented that. So we've been forced to adopt new technologies. Like when you called me about this, you know, I know you're against the plan. You know I'm recommending for it. But I think the process of this is outstanding because we've got to come up with the modalities of getting information to people. And so what we've done is we have a website, firesettlementfacts.com, that we encourage people to go to. We're going to put up this video, if you give me permission to do so, so that everybody can see that. I've already committed to you that if we can figure out a way to do this once a week, every week, our task, and I commend everybody on this panel for participating in this, our task is to try to get out all the information that people need. So as Francis said, you know, they can make their own individual vote. And so, you know, we do town halls telephonically. I transcribe them. I put them on the website. We fire off letters, you know, of what happened in court this day. Whenever there's an update, we'll give an extensive update of what happened, because we have to do the best job that we can to get our clients all the information that's available, that's out there in a world where nobody can go outside of their house. So I don't think anybody had signed up for the idea that we were going to be voting during the COVID-19 pandemic, but here we are. And so we have to use the best techniques that we can, including Facebook Live, to try to get valuable information out to the people that are voting.
Michael, I know that in a recent town hall that you advertised publicly, which I watched, as did a number of others probably on this panel, you talked about how this voting by text, that you had been getting a lot of votes. You've surpassed 10,000 votes at this point, but you also said that there had been some expression of, you know, let's take it down a notch because people were feeling a little bit bombarded. If you can address if you've made any changes since that. And Angela also asked a question to this point: should my attorney be pushing a yes vote on me? It seems as though that would be in their best interest and not mine. Can you address that?
Sure. So with respect to the way that votes are being done, people are, you know, every one of us has one of these. And so it's a device that people, there's 2 billion of them. And so that's something that is universally available. A lot of us have computers. And so we email folks the data with respect to that. But I know exactly which one of my clients have access to text or email versus don't have access to either. And they all got paper ballots. We have people that are available, you know, around the clock from the standpoint of accepting phone calls, accepting emails. We give out that email address at every town hall meeting so that people have the ability to ask the kinds of questions that are being asked here. And then what I do is I write down all those questions, and every Saturday at 12 noon Pacific time, you know, we have another town hall. And really what we're trying to do is just answer all the new questions from the previous week. And I'm talking to 3,000, 4,000, 5,000 people at one time, trying to get this information out. And we'll continue to do that. Our next one is Saturday at noon. We'll do one Saturday after that. I think Jerry's going to actually join this time. And the point is that people are hungry for information, and it's our job to get it to them, which is one of the reasons that I commend Will Abrams for this idea. I really do. I think it's a brilliant idea to have a point counterpoint so people can make their own decision. But, you know, I think last I checked, there's about 500 people watching this right now. So we could either say Facebook Live is a legitimate way to do it and 500 people saw it, or we can try to push people to these Facebook Live links and say, hey, go watch that video. You're going to be able to see both sides. And I really respect and appreciate, you know, Fran being on here and Bonnie being on here and Will being on here, even though we have a different perspective. The important thing is we're distributing information for the good, the bad, and the ugly, so that people can make their own decision. And, you know, the good is it's a lot of money. The bad is, according to somebody, that there's issues. The ugly is if we don't vote this thing in and there's not another plan, we're going to be here for a few years.
And let me just give you a half a minute to respond to this, because the criticism I've been hearing from a lot of sides here is there was so much work that went into putting this disclosure statement that really is meant to walk people through the process and what to do and what it means. And that if you're voting by text, you're basically, you're not clicking that, that link open or reading through the materials the way you might otherwise. Just 30 seconds response to that.
Sure. If you send it all mail, I mean, there's hundreds of pages of materials. I can tell you that that's going to get thrown in the trash just as quickly. We've got the link where people have the access to the information. It pops right up in a PDF. They can read it right there before they vote. The vote comes after the information. But at the same time, we're not just doing that. We're sending out emails with PDFs of the documents. We're sending out mail, physical mail to the people that need it, where they've got the big, 2-3 inches of disclosures. And then we're having these town halls repetitively over and over and over again so that our clients can ask us the questions.
Thank you.
Sure.
I think Bonnie wanted to say something.
Yeah, Bonnie.
Yeah, thank you. Thanks, Jerry. Yeah, I just wanted to say, we think the most important thing, like anytime you vote on a very serious matter, and this is so serious, it's going to determine people's future, it's going to determine their children's future, even their grandchildren's future. It's a very serious matter, this bankruptcy, and it's so important that the fire survivors get all the information they need, and that it's honest information, that it's there's complete transparency as to what this plan is about, even though from our perspective it's not much of an alternative, and the fire victims have not been treated well. But I will say, in our firm, we thought very important that people have the materials, that they are able to study the materials in the very difficult times, because you have to understand some of the fire victims are still living in trailers. It's very, very difficult for them with the coronavirus and living conditions and just trying to get through day by day. But it's still, in our minds, very important that they get sufficient information and that they have time to sit down and actually go through it. So for our firm, we chose the plan where you can't just text it in, you can't email it in. You have to have the hard copy documents there, and the 67-page first document and with the explanation, everything in the shortened versions. And of course, they will have our analysis by the time they're voting. But we thought that was important. And also that they didn't text back their vote to us or email back their vote to us, that they were allowed to vote their own conscience in their own privacy of their own home, and mail that back in directly to prime clerk. We thought that was the important process of having a very fully informed decision, and it very, very important. So I just wanted to add that, and I think that when it comes to voting, there are, and this is a difficult subject to bring up, but there's a lot of money being made by the attorneys. And if you look at a recent Bloomberg article, as Mr. I think Singleton pointed out, there are 5 firms that represent almost 60% of the people who will be voting. And each of those firms, if you take the 13.5, you take the max, and we don't think it will be 13.5, but if you take that max and you determine, well, let me see, there's 60% of the claims represented by those 5 firms, then overall, depending on what kind of fee the firm is charging, it may run from about 1.9 billion to maybe 2.6 billion. So there's a lot of money being made by the attorneys regardless of what kind of claims are eventually processed for their individual clients. And so I just want to point that out. It's kind of like the subros, the insurance folks. They sold their claims 50 cents on the dollar. Who did they sell them to? They sold them to people who, funds who already owned a lot of PG&E stock. So they're going to get a huge windfall. So I think you have to look, as I said earlier, you kind of have to follow the money. There's a lot of rich and very, very powerful people politically and otherwise financially involved.
Well, I think we lost her.
Bonnie, can you hear us?
She froze up.
I think
It
we
looks like
lost Bonnie.
we've lost Bonnie. So why don't I raise a question that goes to the theme that she was just hitting on, because this is clearly something that is resonating with our audience at the moment, which is the question of attorneys' fees. And so Chris asks, can the attorneys also be paid partially in stock? If not, why not?
So I'll take that.
Yeah.
I hope so. I think that the stock has a significant ability to appreciate, but you know, what I tell my clients is, look, Michael Watts is not a stockbroker. I don't trade in the market. You know, this is something that they should get their own analysis done with respect to, but it's not going to be a situation where one class of people are going to get X, another class of people is going to get Y, going to get Z. What I believe is going to happen is this stock is going to be liquidated. And everybody's going to be paid out in cash at the same time.
I lost him again.
Oh, you're back, Bonnie.
Fran?
Okay.
Yes, you're back, Bonnie, but Fran, and then we can come back to you.
Oh, sure.
I'm
Thank you.
I'm not charging my clients any fees or any costs.
Steve, I can't get back on here.
Go ahead, Bonnie, you're back.
Am I back? I can't see myself. Isn't that wonderful?
We can hear you though, and you look great.
Okay, well, thank you. No, but I think that it's very, very important to look at the folks who are making a lot of money off this bankruptcy. And I think Mayor Lazaro said it best. He says you've got bondholders making a huge amount of money. You've got equity of all kinds making a huge amount of money. You have attorneys making a huge amount of money. And our plea is simply that these poor, desperate, and I say poor because they've had to wait well over a year and they're not anywhere. There's no money there yet. That they have to think about this very, very carefully from their own perspective and in their own time, and not be cajoled or badgered to vote one way or the other. And we're just trying to give our clients every opportunity to learn as much as possible. And that's one of the reasons I appreciate this forum today. But I think you do have to look at who's making the most money off this thing. Off this bankruptcy, because it's really kind of an egregious process when you think about it in terms of the judicial system. But the bottom line here is that PG&E unilaterally changed the plan. They added $3.7 billion more in debt. They took the equity cash down from 12 billion to 9 billion. This affected the stock price. And then further, we have the coronavirus tragedy and, really impacting the market. We just think that the stock is not going to be worth much. And other people agree, and including financial analysts. And we haven't seen any financial analysts on the other side saying, oh no, it's going to be great. What I figured out today is it's going to have to be up to $40 a share just to pay the fire victims. And I don't know what it is today exactly. I think it's around, I was looking at yesterday, but I think, it's roughly a little under 11.
Yeah, it looks like it has rebounded a little bit. I want to ask a question that's a follow on to a question that Jared had raised from a person named Eric. And this one is for you, Mr. Watts. It says there is information that Mr. Watts is receiving money from Centerbridge Partners who is an investor in PG&E. The information is that he's been given money to persuade a yes vote among his clients. And there's also a question in there about sort of the financing of your case. Can you address that question?
Sure. Nobody's given me $1 to affect the vote of the clients. I've spent my own money with respect to this case. I can tell you that there was a good degree of attempt by the bondholders to come and talk to me, to get me to do X or to do Y or to do Z. And I told them with all due respect, I'm going to recommend the plan that is superior for my clients. And where this ends up is this. The bottom line is that I know when you're taking a very public role that people are going to take shots at you, and that's part of the business that we're in. But I think that the helpful thing is to have a discussion, not where we're like Shakespeare and shoot all the lawyers. Let's talk about the issues at hand, about the plan. What does the plan do? There's $13.5 billion that's going to allow people to rebuild their houses if we get out of bankruptcy by June the 30th. If we don't, we have uncertainty. We have an idea with respect to a community-based plan that has no funding. We have a former idea from bondholders who went away. Part of their deal with the equity was that they could participate in $2 billion of the $12 billion financial backstop. They put not $1 in. And so both with respect to the bondholders and with respect to the community-owned utility, nobody's put up the $60 billion. And the one entity that has is the equity financiers who have put up hard dollars. And then we didn't even take their word for it. We said, hey, we want a backstop. And so go raise $12 billion of financial backstop to make sure that our people are going to actually get paid. And so the bottom line is we had 3 candidates back last fall. Only one of them has shown up with firm dollars that are ready to go, that can meet the AB 1054 deadline of June the 30th, because without that, we're going to be here with nothing, litigating for the next 3-4 years, as is what happens in most bankruptcies. People forget, and this seems like it's taken forever, but this bankruptcy is so much faster than most other tort bankruptcies. And it's not because PG&E's nice guys. It's because they know that they have to get out by June the 30th of 2020. That's the only reason we're sitting here right now. And if we let that day go, we've lost all leverage.
Michael, thank you for tackling what is, got to be an uncomfortable question. But just to put that issue to rest, you can say that you haven't taken money from Centerbridge, that it has in no way influenced your processing.
I haven't talked to Centerbridge in months. I've talked to the bonds more recent than that. And the bottom line is that the money that I'm spending on this case comes from my law firm, and it will continue to come from my law firm.
Thank you. Well, do you want to?
Yeah, I just wanted to weigh in on this. I think that all of this weighs into the plan and the types of information that comes to you about the plan. And certainly looking at the litigation financing is an important aspect for that, regardless of who your attorney is. And certainly a part of that also is how they're making money off the deal, the types of claims they have, right? So certainly there's a whole host of folks like me who have entire losses of their home. There are other folks who have, soot and smoke damage, which they should be compensated, but that's a different sort of folk who's getting paid. And then there are folks, unfortunately, as we know, who lost loved ones and lost lives in this. And the attorneys who have lots of claims that stretch across those areas or are heavily weighted to one area or another, or perhaps are in the fire claimant professionals or the TCC with different levers and different ways that they're making money, or that have a claims process and other matters that are longer term. So they're looking longer term. So if they make money 5-10 years from now, that's okay with them. And so again, this is not to question anyone's heart or anything like that, because I do not do that. However, it is important to understand how they're getting paid and when they're getting paid, because it does not always align to when you're getting your 20%, or that your 20% means that they get 20%. And so in looking at that in whole and see how that's being gamed is important to do regardless of your attorney.
Yeah, well, I agree with you on that. And I think it's it's abundant on attorneys to make clear that no attorney should get paid before his clients. It's just basic ethics 101. And so I don't think you're going to have a situation where attorneys are getting money up front and the clients are being forced to wait, certainly not with my law firm. Number two, with respect to the kinds of cases, I agree with you. There's different law firms that have different kinds of cases. In my law firm, we didn't accept in clients by and large unless their house burned down. Other people took the claims for people who not necessarily affected by having your house burned down, but you've got the mental anguish claims of running from the fire and the like. And I'm not saying one is superior to the other, but my focus has been, we've got to get the money fast enough that people can rebuild their homes. And that's particularly an acute problem over in Paradise. If this takes another 3 or 4 years before people can rebuild their homes, I worry that town will never come back. And so this time sensitivity is so important, because on the one hand, the California legislature gave us this incredible lever that Fran used well, that we used well to force these companies to pony up quickly, knowing that we were using that lever of June the 30th of 2020. And that lever also comes with a responsibility. And that is, if for some reason we don't get a plan out by June the 30th of 2020, particularly in a COVID-19 pandemic situation with the state budgetary shortfalls, I worry that AB 1054 is not going to be recreated again. And then we're going to be just all holding what's going to eventually be a sell-off of the company at dramatically reduced values. And so I think it's I think it's a fair and reasonable plan, but more importantly, it's the only plan, in my view, that we can get done by June the 30th of 2020, so that Californians can move on with some understanding that the governor forced reforms of this very bad company to try to make it one that doesn't continue to repeat the process over and over again.
All right, so at this point, what I would like to do is ask our final question of the panel, the final question of the event. I want to thank everybody. Jason will have a couple of announcements at the end about future events and to help us close out, but I'd like to ask a question and to give everybody about 60 seconds to respond to. So I'll go around and give you a chance to respond. And here's the question, which is from Richard. How will the fact that claimants are feeling left out, not truly understood in what they lost, and have went through be addressed, and by who, and elevated back to what level of deserved importance? And I'm sorry, I'll paraphrase that. So folks feel like they've been left out by this whole process, and they've lost a lot. Like, how do we elevate the level of importance of their feelings, right? And I'll continue. It appears to many that the lawyers, shareholders, PG&E itself, politicians, insurance companies, and CEOs have first priority over what the fire victims will justifiably receive. It's been difficult to honestly trust anyone in what's going on and what settlements can be expected for those who have lost everything, including family, friends, a lifetime of special belongings, animals, their emotional stability, along with being able to live a normal life again. I guess, what would you say to this person as they decide how they want to cast their vote on this plan of your organization? And I'll start with Bonnie, if you're ready. Bonnie, you need to unmute.
Jared, my computer went off there for just a few minutes, so I didn't hear the entire question. Could you repeat it, please?
It's something of a long question, but the thrust of it is, what do you say to the person who has lost everything and suffered horribly as a result of fires that PG&E has held liable for, and they're trying to decide how to vote on this plan? And just 60 seconds of what you would say to that person.
Right. Well, what I would say to that person is to read every single page of every document that you have on that plan, and to put it in your own context with you personally. I am very confident that this bankruptcy judge is not going to allow the sort of contingency plan. He will have a plan in place, and it will be a good plan. And the reason one of the reasons it will be a good plan is because you've seen all these different groups who have a huge stake in this bankruptcy. And those are the bondholders, that's equity. It's the sub-ros who, are going to make it a incredible killing off of this and the folks that they have sold their claims to, and they're not even entitled to those claims until the fire victims are made whole. But you have to look at, there's so many different entities, there's so much money involved, and there, for that reason alone, even if we didn't have a good bankruptcy judge, there will be a plan. This is not the plan. This is not a choice that people are really given. It's just vote yes for a crummy plan or don't get anything. That's not the scenario that is ever a good scenario in bankruptcy. And I'm confident that that will not be the scenario here eventually. So I say study everything, make up your own mind, you know your own family situation. And it depends on what you want out of this bankruptcy. If you want full and fair compensation, then you would vote no, because this is not full and fair compensation. But if you need money quickly, like many do, then you probably have to say, okay, I'm going to settle for a lot less. That's a personal decision. But I say to make a fully informed vote, you have to read everything, you have to look at everything. If you have an attorney, call your attorney, talk to them about your questions. A number of folks do not have attorneys. It's going to be particularly hard. And also, if you've already voted, you can always change your vote. People should know that. Yeah, all they have to do is go online to Prime Clerk and you can change your vote. Thank you.
All right, Jerry, and then Fran will go to you after that.
Sure. What I would say is, first of all, to echo what everyone said, it's important that you educate yourself. But basically, it comes down to two choices, and those choices have been made very clear by the bankruptcy court. If this plan is approved, then people will get paid 90 to 100 cents on the dollar within the next 6 to 12 months. If the plan is not approved, then there will be a sell-off of the company's assets that will take 2 to 4 years. There will be a significant discount, and people will get a fraction of what they would have gotten otherwise. So to me, those choices are very clear, which is why we're supporting the plan. But to address the issue that the questioner had, which is a very good one, is basically, when does this become about us? When does our pain, when do our losses get considered? And the answer to that is during the claims administration process. That's something that we've been working on setting up, that Justice Trotter and Kathy have done an excellent job. And they're going to go through and they're going to look at each and every element. And they are going to pay, we believe, 100 cents on the dollar. I think Fran and his people did a wonderful job negotiating that 13.5 billion. We think it will be enough to pay everyone 100 cents on the dollar. But if not, it's going to be very close. But more than anything, that claims administration process, when your claims are there, when you get to explain what your family went through, when you look at what you lost and you have experts evaluate that, that's your opportunity to tell your story and to get fully compensated for it.
Thank you, Jerry. Fran, and then we'll do Michael after. And please, I will try to keep this as close to a minute as possible.
Yes, I'll keep this very short. I believe that there is a probability that the fire victims can get 13.5 billion all cash before September of 2020. That's a backstop for the PG&E plan, which I don't think can ever be finalized, because I don't think they can come up with the financing. I don't think that they can come out of bankruptcy with investment grade securities that anybody wants to buy. So that's what you have to think about, you folks out there who are going to vote for this. And it's not necessary to vote right now. You can wait. You don't have to vote until May 15th. Why don't you wait and see what happens in the next 3 or 4 weeks? That's all we're suggesting. And if you have a lawyer, speak with your lawyer. If you don't have a lawyer, there's a lot of lawyers out there that you can find to talk to about this. There's a lot of them. So thank you all. And I just want to say one thing, because it's the last thing I get to say. We all should follow Dr. Fauci's advice that alcohol kills the virus. So everybody go out and have a couple.
I think we can all agree on that.
Yes, I think we can too. Michael and then William.
Sure. First of all, I do want to thank Mr. Scarpula and Bonnie and Will for participating on this, and Jerry on the other side with me. I think what I would tell people is this. Nobody wanted to be in bankruptcy court. We all wanted to go try your case. We wanted to let juries decide this, but here we are. I think we've all learned a lot of bankruptcy court, but what I've learned is this. Hope is not a plan. I hope that by September 30th, somebody's going to put up $13.5 billion in cash. If in a 2-hour Facebook Live program, we don't even know who that person is that has $60 billion lying around. We don't know who the banks are that are saying we'd like to give it a shot. You know why we don't know? Because when they filed document number 306 back in September, when everybody was still taking the bids from the different plans, nobody came forward with any money except for the equity participants that we have. The bondholders have gone home. Nobody, this mysterious bank that's going to come up with $60 billion for this other plan. And they say by September the 30th. Well, the problem with that is if we're not out by June 30th, we've lost AB 1054 and this thing is not securable. And so we have a deadline that worked to our advantage in getting 13.5 billion, and that's June 30th, 2020. That's the deadline. But it's something that kicks as hard as it shoots, to use a Texas phrase. And so what I want people to understand is that you cannot vote on hope. You have a plan that has actual equity behind it, $60 billion. And then your other option is, well, there's an article from the mayor of this or that hasn't raised any money. And I'm very concerned with the idea that, hey, there might be a better plan out here. There might be a chance if somebody had a chance to compete for it. They had that chance last fall. The TCC unanimously voted for it. 13 out of 13 fire victim claimant professionals unanimously voted for it because we negotiated it. We believe it's in your best interest. We believe it's the thing that builds your homes now. You've waited long enough. Litigation is interminable, how long it takes. And we've got $13.5 billion in a plan that is backed up with actual funding here. It's ready to be used. It's time to rebuild your homes.
Great. Thank you, Michael. And then William, to close us out.
Thanks very much. I've really appreciated being on the panel, and it's a great question. I've struggled with that myself. I was originally represented by a fine attorney, but was not getting the questions that I needed to feel comfortable with the plan and the direction of the bankruptcy proceeding. So I got engaged. There's lots of other folks who are getting engaged, but the bankruptcy process is not designed for us. It is not designed for the victims. The bankruptcy process is designed for the debtors, in this case, PG&E. And part of that comes across in how this thing unfolds. I would ask everybody to please go out there, get engaged, get as much information as you can voting on the plan, and please do not look at this sale. One thing that I can agree with Michael on is anybody who's flashing to you 13.5, big pot of money, come and get it. All you have to do is vote yes or something along those lines. There is no reason to push for an early vote. That is in no way, shape, or form could anyone argue that an early vote is a good vote. Let things get more solid. Make sure you're identifying the differences between facts and fiction, which is the name of this forum. Thank you.
Right. And then Jason, I think you were going to say something and then end this. And thank you again to everybody for such wonderful contributions and enthusiasm. This has really been fantastic. And a special thanks to Lily for being a great moderator and for thank you.
Well, thanks for being my co-pilot, Jared.
Yes, and to thank everybody in the chat space who've been online. We've had consistent viewership throughout the whole 2 hours. Really appreciating everybody bringing their all to the questions and the chats that they were offering, both in advance as well as through the chat space again. I'd like to thank specifically Jared and Lily for their skillful moderating, but also recognizing, again, this came together in 5 days, people, and we had a commitment of theirs to facilitate and to help shape the questions, to educate themselves further on the pulse of what's in our community today. I think that's the the issue that for me has led to the creation of this platform is that things have been changing so quickly. And we heard that there toward the end, like, okay, to the extent we wait for 3 to 4 more weeks, what can happen? What can we expect? What's out of the league of expectation? But I still don't have a good sense of all the ways in which this is shaping out. I think we're looking at a couple of different dynamics that are in the bankruptcy that get replicated again when we have a dialogue like this. We have a chance to gain insight into the kind of things that have been going on in the courtroom that in this whole bankruptcy process, which at times can be really arcane and technical. And at the same time, we have the benefit of experts who can come and help us understand, make sense of what's complicated and hear different perspectives, but also to identify more and more what's complex about this, what's unknowable about this, where are the parts of this deal that are really about speculation, about risk, and about what is it that my family can risk in this particular solution if I say yes, no, or if I choose to wait. I see this as like holding a balance between the technicality. Some of us, really want to get into the details, others less interested. I want to know maybe how to trust myself in making this decision. I need to balance the technicalities, but at some point I'm looking for a sense of who to trust, why did I trust them, how does that influence, or how is my family's perspective on risk influenced by the views that are in place, and how do I make a decision at the end of the day? There's a lot we're having to grapple with, and for many of us, this is maybe one of the largest decisions we have to make in terms of financially recovering from the fires, but also emotionally and psychologically letting this to be put behind us. And so with that in mind, we've committed to having this platform as a place to bring voices together, to bring a broader group of voices, not just experts, but others who have things to contribute to this. We're interested in understanding the impact on the communities that we live in by this type of a settlement. We want to understand what it's going to be like for each individual to make this decision and finding their way home. So with that in mind, continue to inform us as to how this prototype has been really. We took an effort to design it in a way that we think will help foster additional communication and additional ways to get answers and create an informed electorate as a group of interested parties, because we are interested, we do care, and our votes matter. So thank you again to the panelists for being here and contributing so actively and passionately for your sides. And please, let's continue to be in dialogue about what's meaningful for this community so we can prioritize the views of the fire victims for once and for all. Thank you.
Thank you.
Thank you.
Thank you, everyone.
Thanks.